America's dirty alright.
Don't you guys hate it when a show recasts a character in the middle of a season? I mean, as a viewer, it just throws me off. Well, if you're with me on that point, you're going to hate what's going on in Young Thug's YSL trial. Because in the last month, we've seen not one recusal, but 2 judge recusals. And now we're on to the 3rd and hopefully the final judge. Let's break down the circumstances of the back-to-back recusals and how they affect the YSL trial. Now, there are a lot of judges involved, and I don't want to get you confused, so let's lay them all out. First, there's Judge Glanville, Judge Krause, and Judge Ingram, and Judge Whitaker. This story begins with Judge Glanville, who's already been featured in one of my past videos. He and defense attorney Brian Steele went viral after Judge Glanville had attorney Steele arrested for not revealing his sources for information shared during an ex parte meeting. An ex parte meeting is one in which a litigant in a case, here the state of Georgia as the plaintiff in the case, has access to the judge in the case without the same access being granted to the adverse party, here Young Thug and his attorney. After first denying a motion to recuse himself and a motion for a mistrial, Judge Glanville turned to Judge Rachel Krause to determine whether he should be recused. This was not in response to the first motion to recuse, the one filed by Young Thug's attorney, but instead in response to the 2 additional motions to recuse that were filed after that. In other words, pretty much everyone except Judge Glanville thought that Judge Glanville was over the line. And to be clear, the line is not partiality or like actually being dirty, but instead the appearance that you could be partial, that you could be, in the eyes of a reasonable person, whatever that is, unjust with respect to the case at bar. And given the low threshold requirements for getting a judge to refer such a motion to recuse to another judge for consideration in Georgia, 2 such motions, then that's what Judge Glanville probably didn't want to do. But he did eventually do it. He sent the 2nd motion and the 3rd motion to a judge unrelated to the case, to Judge Rachel Krause. 2 weeks ago, on July 15th, Judge Krause ruled that Judge Glanville should be recused, stating, "It's worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from presiding further in this case." Well played by Judge Krause, because while she kneecapped Judge Glanville and she kicked him out of the case, she did so in the most affirming and kind and gentle way. Essentially, she said that she knew that Judge Glanville was fair and hadn't done anything wrong, but other people might be confused. So it makes sense that the case should be moved to yet another judge, since not everyone might see it so clearly as Judge Krause does. She really treated him with kid gloves on the one hand. Now, on the other hand, she did kick him out of the case. This leads us to the next judge in the case, Judge Shakura Ingram. And now everyone breathes a sigh of relief, right? The defense attorneys got what they want for a fair trial, at least in their eyes, and people can proceed with Georgia's longest trial ever. Except Judge Ingram had other plans, because on July 17th, she filed an order of recusal excusing herself from the case without a motion. Now, we just watched Judge Glanville fight to not be recused. So why would Judge Ingram willingly take herself out of one of the most watched trials in America right now? According to her filing, on or about June 1st, 2023, Christian Eppinger, one of 18 defendants, was severed from the ongoing YSL RICO trial on the criminal action that was recently transferred to this court by random assignment. Although there is no severance order in the record, the court was apprised of the circumstances that directly led to Eppinger's severance. More specifically, the deputy assigned to and responsible for the courtroom and personal security of the undersigned, that's how judges talk about themselves, they don't say their names, they say undersigned, for nearly 6 months was arrested. Said deputy, who was still assigned to this court at the time of her arrest, is accused of number 1, colluding with defendant Eppinger during the current trial to commit a felony, and number 2, endangering the safety of citizens within Fulton County Courthouse, because this court's former assigned deputy could be called as a witness in any future proceedings. In this case, this court may be called upon to assess this deputy's credibility or rule on matters related to her criminal prosecution. This may undermine the public's confidence in the impartiality of the proceedings. Thus, after careful consideration and consistent with CJC Rule 1.2a, promoting public confidence in the independence and impartiality of the judiciary, and CJC Rule 2.11a, requiring disqualification when the public might reasonably question a judge's impartiality, the undersigned, again, that's how judges talk about themselves, hereby recuses herself from this criminal action. The clerk of the court is directed to reassign this criminal action to another judge. Now, if you read between the lines and the multiple articles released, it appears that former Fulton County Deputy Akeba Stanley was arrested and charged with reckless conduct, violation of oath of office, conspiracy to commit a felony, and hindering apprehension of punishment of a criminal. All of these charges are based on the inappropriate romantic relationship that she had with Christian Eppinger. As the accused was a former deputy assigned to Judge Ingram's courtroom, the judge felt that there would be a conflict and chose to recuse herself. Wow. We need to have a reality check here. This is insane. For real. The number of times that a law enforcement officer ever gets arrested or is called for a witness in a criminal case is very, very small, except as someone doing an investigation. And then for that person to be connected to a judge's chambers and not someone like out in the public, out interacting with people who might be offering bribes, who might be offering attractive ways to get in on a criminal enterprise, it's just really rare. And then on top of that, for it to be connected to an ongoing case that winds up on that judge's docket, the ysl-trial saga was already groundbreaking in terms of how long it's been in process, how broad and wide-ranging it is, and it is attached in some ways to a celebrity. It's an unusual case, so maybe we shouldn't be shocked by this wrinkle, but I still am. But in terms of recusal, the judge really caught a break here. And just to be clear, most judges are not media. They're not desperate to mug for the cameras. In fact, quite the opposite. They're civil servants. By and large, they are nerds who did well in college. They are nerds who went to law school. They did well in law school. And then that they figured out their passion is the law as a category. Their passion is not like winning or deal making. Judges generally just like the law. That's different than us lawyers. Lawyers like me, we like to win. We like to make money. We like to make a name for ourselves. We like to help our clients. But judges are a different breed of cat. They just tend to shun the spotlight. So if they can legitimately avoid the clown car spectacle that is the Young Thug racketeering trial, then they want to. And Judge Ingram was 100% right that she had a possible conflict of interest and a legitimate justification for a recusal. She made the right choice from a judge's ethical perspective and also from the quality of life perspective. It just so happened to be for a very bizarre reason. And now we've arrived at the final judge, Judge Paige Reese Whitaker. And so far, it looks like she's going to stick around. Now, things just started back up for the trial on Tuesday, and it was a busy day. Judge Whitaker denied a request for a gag order against the defense by the state, as well as multiple motions for bond and a couple of motions for mistrial. One of the biggest revelations made in one of the motions to dismiss is that there is a second, well, technically a first ex parte meeting that occurred on June 7th, 3 days before the ex parte meeting that led to Steele's arrest and Judge Glanville's eventual recusal. In a transcript from the first ex parte meeting, Judge Glanville is quoted as saying, "There's a lot of stuff that's going on in the background, and it shouldn't really have anything to do with you all's case. It really shouldn't. But I think it does in some way. Outside agitators and everybody else who I think are trying to influence. The defense attorney who filed the motion to dismiss is making the argument that the transcript of the first ex parte meeting proves that there was bias in the trial and therefore makes it impossible for the trial to continue. Maybe. This is a double ultra marathon of a trial, and no one actually wants to start over, including the lawyer who filed this motion. Presumably, they are being paid a flat fee for the trial, and starting over just costs them time. But they are obliged to ask for it if the facts warrant such a request, and they kind of somewhat do sort of warrant it here, because ex parte communication is simply disfavored. It's bad. It's a bad look. And if you don't believe me, just ask Judge Glanville, who got benched for ex parte communication that he thought was fine. But he was wrong. I'm guessing that this latest motion is denied because the defense is not able to say in any concrete way how they were harmed by the prior communication. And that judge is already gone. So instead, let's put this case on skates and just try to push it forward. That's what I'm betting we get from Judge Whitaker. Now, as of the filming of this video, the jury is set to return next week. So go ahead and drop your pro se opinion down below in the comments. What are your thoughts going into the next phase of the YSL trial? Do you believe that there should be a mistrial? How do you think Judge Whitaker will handle the trial coming up in this late part of the game? Let me know your thoughts, and guess what? I'm not going anywhere, unlike some rotating judges in this trial, so hit the subscribe button, and I will see you soon. Could be called as a witness in any form of proceedings. Ugh. This deputy's credibility on matters. Wow. Y'all enjoying that out there?